Hey, what's up, guys? Welcome. Oh, my goodness. Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. Just a humble man. A humble man with unhumble opinions. Here to discuss some legal news and topics with you guys in the daytime. So, I will probably wait just a minute and do a re-intro to the show in a weird way in just a second, just to kind of catch people as they come in, maybe filter in during the day. This is not a normal stream time, and that is part of the reason I'll kind of have some opening words as we go. But for those of you who are here, thank you. The pre-show chat was active. The pre-show chat is always best chat, and you guys should join it if you have not participated. Oh my goodness, I got the hiccups. Let's lock down the country. Let's lock it all down immediately. So today we are going to be talking about Donald J. Trump for president versus Bakvar et al. See. Versus Bakvar et al. Let's see. I am currently live. You're right. I think 1 second. I have to respond to a text. Oh boy. Okay. So yes, this is Donald J. Trump for president versus Bakvar, whatever et al. That is the Pennsylvania Secretary of State and the final boss in Pennsylvania, who is putting a sad ending on the Trump campaign's legal efforts in that state. And this was done on November 17th. So about 6 days ago, oral arguments occurred in this case. That's what we're listening to. It was since it has been dismissed with prejudice. It is on appeal at the U.S. Court of Appeals. I'm going to talk to you about, I guess, the status, how we got to the dismissal. We're going to do that again through the oral arguments. And then we can take a look at what their chances are on appeal in this case. And let me just piss everybody off at the onset. They aren't good. They aren't good chances. They're not good at all. Even on appeal, they're not good. The Supreme Court prospects of this case are not great. And a lot of that has to do with the legal strategy they took. So, and we're going to talk about that. Huge missteps made in this case. Huge missteps were made. And this is, but let me roll that back a little bit and clarify a couple things. All right. These cases are really, really hard to bring for the very reasons that they've been losing these cases. Okay? This is what we're going to be talking about as we go through this, as the judge, as both attorneys lay out their arguments, depending on if we get into the judge's questioning or not, I don't know. As we get into these things, I'm going to illustrate what parts of this are so dang difficult. And so when I say that they made some really poor choices, it's not like there are good choices to make. There isn't some magical strategy that gets this all done. And that's the problem. It's how we conduct elections. It's where constitutional authority is delegated. These things are all very complicated, but they're also very resistant to court intervention. And with Probably good reason. Probably with good reason, because we don't want courts overriding the will of the voters. Now, the counterpoint to that is, of course, well, what if there's a bunch of fraud and fraudulent voters? It's like, yeah, that's a big problem. And it's a hard one to solve because we really, really don't want courts overriding the will of the voters. And so there's a very delicate balance that has to be walked on this, a tightrope, so to speak, between balancing the interest in preserving an anonymous election and everyone's right to vote versus preserving the integrity of the election and excluding votes that shouldn't be included. And that is the dramatic tension that we have established in this case very well. And we're gonna talk about that as they come up in arguments. I have pre-gamed a good chunk of what I think we'll get through today, and so I've also been reading through the opinion on the dismissal, so I can hopefully highlight specific elements or specific things where maybe arguments didn't go so well. But these cases are rarely decided at oral argument. All right. They really aren't. And in this case, the pleadings themselves did most of the damage. But the oral arguments are important because they summarize the pleadings in a nice, digestible way. That's the whole point of them. And they can illustrate certain hot spots. So that's that. Briefly, before we get started, if you're new here, if you're new to this channel, or if you're just whatever, I don't know, if you're watching from home, enjoying this, I hope, know that I do typically a live stream every weeknight at 11 p.m. That's the normal time, including today. Although I am delving into the idea of doing additional shows during the week, during daytimes. I'm going to be testing out some times and days to see if those things are scheduled. If you like daytime content, make sure you tell me about it. Hit like, share it, leave me a comment. Tell me what you want to see if you like these shows during the day, because the nighttime stuff doesn't work out for you. I know I stream very late for a lot of people. So please help me out. Help me out on that. Okay. There are a couple of chats to get right out the gate, and then we'll get into this video post haste, and we will probably be going till about 5 to 6 p.m. Today. Now, I don't think we're going to get through all the hearing. The total hearing is about 4 hours. We're certainly not going to get through if we just played straight through. But even so, I don't think we're even going to get through all of the juicy stuff today. And I will likely be revisiting this for another daytime show, maybe even this week if I can wrangle it up. So here's hoping. Okay, first couple chats. Viden, the cold one, says, look, don't just hurt the real Nick. Or wait, look, just don't hurt the real Nick. We know the truth. If you hurt Cherkun, we will come for you. Brian Mulvaney says, hey, buddy, glad you're feeling better from your exhaustion. And as far as the hearings are going, poor Rudy and his team are chupping up his chances, isn't he? It's not entirely Rudy's fault. It's not entirely Rudy's fault or any particular identifiable team member's fault. Again, as we get into this, we'll talk about just how hard these types of cases are to bring from the onset. It's getting past the initial hurdles, and they'll show up really quickly in the arguments. I'll pause and I'll explain and link to, verbally link you to where in the decision these things went wrong. The Dragon's Treasure. The Dragon's Treasure sent in a couple chats real quick. He says, Black Friday is almost here. But to hell with crowded malls. Instead, try some weeb tea and give back to the community. Use coupon code NICK to get 10% off and give Nick 5% back. Hey, cool. And we will use the funds to finish my bourbon whiskey flavored tea. He also says, buy more than $50 and get an exclusive tea not sold in stores thedragonstreasure.com, a haven for anime and tea lovers. Now back to how Donald, Bernie, Trump, Sanders can still win. Thank you. Thank you. All right, guys. Yeah, check out dragonstreasure.com, thedragonstreasure.com for all of your anime tea needs. It really is great tea. Hand cut, good sized tea leaves. It's loose leaf tea. It's not like a powdered pile of crap and some cheesecloth. It's loose leaf tea. You brew it yourself. It's really good stuff. Great blends and thorough instructions on each bag, so you make sure you brew each particular tea the appropriate way. Really good stuff. Also, yeah, let's get that bourbon whiskey flavored tea. Let's get that moving as soon as possible. R.W. Bimby says, left loves court override will of the voters. How many times did California voters pass propositions protecting border or marriage? Left always takes it to court to cancel democracy votes they don't like. They do, and they're very good at it. However, they're attacking a different thing than a vote. They're attacking the policy that the vote is for, which makes their attack much, much simpler. And that is again, part of the difficulty in assessing how to even approach a case like this. Oh, my word. Okay. Here we go. So I have skipped the legal team's introductions. I've skipped the judge talking. We're about 10 minutes in. And this is right where the judge is asking Rudy Giuliani to give the opening remarks for the plaintiffs. That would be Donald J. Trump for president, plus a couple individual plaintiffs. And then the response will come from the firm representing Bookvar. Rick Nikita says Pennsylvania has banned the sale of alcohol. That's partially true. It's and in honor of that, I will have a drink on stream because Pennsylvania has banned the on-site consumption sales of alcohol after 5 p.m. So now in Pennsylvania, you're supposed to be a degenerate day drinker. That's what they have said, and you guys should all join me, especially if you're at work, in being a degenerate day drinker on this lovely Monday. I'll be imbibing some peg leg porker, Tennessee straight bourbon whiskey. No propositions in California needed to protect the marriage of flavors in peg leg porker. Was that too much of a joke? Like, I wonder what jokes are even allowed to not be offensive. Like, obviously, I'm not trying to offend anyone with that joke, but I hope someone was offended in the end. Okay. Thank you, Rick Nikita, for pointing that out. Oh, it's a great whiskey. It's a great whiskey. If you're near Nashville, you should get some. All right. Let's do this. And I'm going to be as calm and collected as possible. Let me make sure you're not muted, which you are. Go. Here we go. Have the right output. Okay.
Easier for you to do that. Stay right at counsel.
Thank you, Your Honor. May it please the court. My name is Rudy Giuliani, and I'm here on behalf of the plaintiffs. I thank the court very much for allowing me to be admitted pro hoc vice. Your Honor, the best description of what we're alleging, and again, on a motion to dismiss, our allegations have to be deemed to be accurate and true. Of course.
Okay, so on a motion to dismiss, what he's talking about there is any factual representations need to be taken as true for the purposes of the motion to dismiss. He's right. He's right. They have to assume the allegations are true. I want you to remember that because this case has been dismissed even assuming the allegations raised are true. So as you listen to Giuliani's speech, keep that in mind, but keep something else, a surprise in mind, and that is the real question that is a problem in this case for the Trump campaign is what are the actual assertions being made? And more importantly, what actions are being brought that are being dismissed? Okay? Those things, we'll talk about that as we go. But they are all considered as true for the purposes of this hearing, just to see if the case can move past the dismissal.
Of course, that's subject to testing during the hearing. But the best description of this situation is it's a widespread, nationwide voter fraud, of which this is a part. And that's probably the reason I'm here, Your Honor, because this is not an isolated case. It's a case that is repeated in at least 10 other jurisdictions. It seems to me, in the words of Emmanuel, not the prophet Rahm Emanuel, this is one of those situations where you never let a serious crisis go to waste. It's an opportunity to do things you think you could not do before. Specifically, the crisis was the pandemic that was taking place. The opportunity to do something that had been resisted for 2 decades, which is to create a wide-scale, open, mail-in ballot process, which we had been warned about by none other than Jimmy Carter and James Baker in a report they did in 2006, I believe, on election reform. And in it, they very, very seriously warn us, quote, mail-in balloting is the largest source of voter fraud.
Okay. Yes. Mail-in balloting is the most susceptible to voter fraud. It was covered in a Jimmy Carter document. It's been covered in, excuse me, it's been covered in a Supreme Court case. It's been covered by the New York Times, who has since changed their minds. Rudy's going to talk about all these things in just a minute. Mail-in voting is the most susceptible to voter fraud. Now, there's a logical consistency argument that I must make here. Relative statements can be true and also non-impactful. I don't believe this is correct, but logically, mail-in voter fraud can be the most susceptible, or mail-in votes can be the most susceptible to fraud of any other type of voting, and still not be a significant enough amount of fraud to change an election. That is a possibility. So this is just a conceptual problem with the narrative around mail-in voter fraud being the most damaging. And I pointed out this inconsistency in a different matter going the other way the other day. It's only intellectually oh my goodness. It's only intellectually consistent to go ahead and point it out now. Now, I believe there's a significant amount of fraud. I have no problem. I'm even willing to take the Republican Party at their word entirely on the amount of fraud that took place in this election, and fully will swallow the idea that there is enough fraud to swing this election. Okay? I'm 100% willing to accept that. That doesn't change how difficult it is to bring this fraud into court and to get the court to rule on it in such a manner as to overturn the outcome that happened. All right? And this is probably a problem that needs to be addressed on a grand scale, and whether or not it's addressed in this election at all. Dr. Satan RX says, F asterisk Tom Wolfe and his economy killing rules. Yes. F asterisk all governors. All of them. F asterisk every single one. Except maybe DeSantis. That's the Florida guy, right? Okay, here we go.
And I don't think there's any dispute about that. Mail-in balloting is exceedingly dangerous and can much more easily be used to effectuate a voter fraud, a deliberate voter fraud. And we believe that in this case, we're going to prove that former President Carter and former Secretary Baker were prophets. This mail-in system, this new mail-in system, which, as I said, President Carter warned against, Justice Souter warned against it, Even the New York Times wrote articles explaining how dangerous this was. They've since changed their position. And this whole situation, on a smaller scale, goes back to as early as 1960, when Mayor Daley held back votes in Chicago so that he could tidy up the result to make sure it came out the way he wanted. Or you can go to 2018 in Florida, in the governor's election and the Senate election. The votes from Palm Beach County and Broward County were withheld for 10 days to see if they could catch up until a group of ballots were found heading from Jacksonville to Palm Beach that appeared to be fraudulent ballots, and the election came to an end. And Florida reformed its system, so we didn't have that happen again this year. Well, this practice of holding back votes, which happens in my city also, Your Honor, is a time-honored practice that's done in the big cities, particularly the corrupt big cities in our country. All of a sudden, we now have, it's almost like, putting them in a candy store. We now have a wonderful opportunity to hold back votes, even to produce votes after the election to make up a deficit. So what happened? In 2016, in this state, in the Commonwealth, there were only 266,000 absentee ballots. This year, so far, 2.6 million.
All right, so a big increase in absentee ballots. That is, of course, the allegation of the source of the fraud. However, I want you to pay attention to the numbers that they cite later. They're going to suggest that, fully half of those are the subject to fraud, which is too high of a number statistically. Now, that's not exactly what they're saying, but it's how their argument comes out that makes it a problem. And a reminder that the remedy sought in this case, is to invalidate every vote in Pennsylvania, every single one. 6.8 million votes is that's what they're asking the court to do, is at least invalidate, or at most invalidate, every vote. If the court was unwilling to do that, they wanted them to invalidate every vote from specific counties, which makes up quite a lot of them. Why is it too high? It's a stretch to assume that half of all mail-in votes are fraudulent. And that's not actually what they're arguing. It's just how the argument comes out. What they're actually arguing is that roughly half of the mail-in votes occurred in places where Republicans were not allowed, and in many places Democrats were not allowed as well, to observe the actual counting of the absentee ballot. Now, that's an okay argument. It's an okay statement. The problem, again, is going to come in their proposed remedies and in their proposed problems, or their proposed issues for the court to address. And we're going to get to those in just a minute. He's almost there. He's got to expound for a little bit. Let me be clear. At this point of the case, I think Rudy's doing a fine job in his oral argument. I'm not actually criticizing him yet. My critiques of Rudy come later. And a lot of the critiques in this part will be Rudy plus the filings not being geared to accomplish what Rudy's talking about, okay? So at this point, he's doing fine. His argument is compelling, right? We've got very, very big problems with voter fraud. It's not just here. It's not just this one place. It's big. It's happened in the past. It's happened all over the country. Now they've just found a way to go ahead and systematically implement it. This is a good argument. Not for the thing they're actually arguing for in court. So here we go.
A totally different world. And the number of, and the allegations that we're talking about take place in each one of these counties, but the principal ones are in Philadelphia and in Allegheny. Both of them, Democrat machines, controlled by Democrats in the case of Philadelphia, 60 years, well known for voter fraud. I don't know if you kept a list of all the voter fraud convictions in Philadelphia. I don't know if it would exceed Chicago or not. And just this year, a judge pled guilty to voter fraud, and Congressman Ozzie Myers has been indicted for it. And then I can go on and on. Relevant to this case, Philadelphia, Pittsburgh, we used in this state. Just a little bit to the west, Detroit, similar allegations. Milwaukee, similar allegations. Meaning, all of a sudden, for the first time ever that I've ever heard of, inspectors, watchers, observers, they're called different things in different states, weren't allowed to observe the counting of absentee ballots.
All right, let's get to the first big point of error between Mr. Giuliani's opening statements here and the filings. They took this out of the filings. They had, in their original complaint, they actually had this stuff in the filings about the failure to observe, the inability to observe the counting of absentee ballots. They removed this from the complaint. It's not in there. They have factual assertions surrounding it. Okay? They have factual assertions surrounding it. They bring up the stuff that Rudy is saying, but what they don't have is an actual count asserting injury and demanding remedy based on these facts. They just have them in there as facts. Now, what they later said was that the removal of them was an oversight, and they had asked the court to again amend their petition, and the court said, no, you don't get to amend the petition due to the emergency nature of the proceeding. No, you don't get to do it again. So, all of the stuff Rudy is going to talk about in regards to the counting of absentee ballots not being observable by election watchers is great stuff. They took it out of the document. Why they took it out of the document is a complicated question, but ultimately a terrible decision. And this is what really screws up their chances on appeal. Because on appeal, they don't get to raise new issues. They won't get to raise this issue on appeal because they took it out of the document. The only hope that they have to raise this issue on appeal would be to rule that the failure of the court to permit them to file a second amended complaint was overly prejudicial. And that is a tall burden to bear in an emergency proceeding with a deadline of today. Today is when the secretary in Pennsylvania is set to certify the ballots. So, this is one of those big missteps. And they said that it was an oversight or it was an inadvertent removal, but they did remove all counts, including this, from the document. Now, there's two ways to actually take this. There's two ways to actually take this. Wolvenar, that line just incorporates all the factual statements into the cause of action. It doesn't, that's paragraph 150 you're talking about. That inclusion line doesn't actually change what they're suing for. What they're suing for are the two things in the counts. And the two counts that are brought up. And those do not include an election tampering violation based on restricting of poll observers. Okay, so to clarify that, it does include the factual allegations that they made, and they may be able to then use the fact that they included the factual allegations to say that the counts were removed inadvertently. But there's two ways to look at this in truth, because there's always what the lawyer says happened, and then there's what actually happened, and those two things might be the same thing or they might be different things. All right. So Rudy Giuliani says that in the revision, in the First Amendment complaint, they were inadvertently deleted, these counts. That very well could be true. What also could be true is that whatever lawyer was drafting the First Amendment complaint had a specific idea about the likelihood of success on those particular counts or any particular counts, and he excluded them intentionally, not realizing the ramifications of what would happen based on something else. Now, what did happen between the drafting of the first amended complaint, or between the original complaint and the first amended complaint being filing, is important to consider. There was a decision in federal court in the Western District of Pennsylvania. Okay, so just a little bit over from where this is, there was a separate decision in that court, and in that court, not the Donald Trump campaign, because they weren't bringing the issue. However, some individual voters got absolutely shut down on their lawsuit for lack of standing. Standing in federal court is a very important thing. It is how the court is actually able to wield their power. To have standing, you must point to an actual case or controversy. You must show that there is a particular injury, in fact, to the plaintiff, that the injury is reasonably caused by the actions of the defendant, and then third, that the court can provide redress. These three issues have to be resolved in every single federal court case. All of them, bar none. In fact, if you don't raise a standing argument in your opening paperwork, your complaint, your answer, if there is not a standing argument in there, the court is required to do a standing analysis on its own volition. The court must take it up. It's what's called sua sponte. So the court has to address the issue of standing, because the court has to address the issue of whether or not they even can hear the case in the first place. This is a federal court thing. State court standing is different. So, but we're in federal court now. And what happened between the drafting of the original complaint and the drafting of the first amended complaint is that there was a standing ruling in another district in Pennsylvania that eliminated several causes of action from this court, or from this original complaint. And that's why they actually deleted them, because they were going to have problems under the standing issue with them. So maybe they got left out inadvertently. Maybe they intended to bring those back in another cause of action and ran out of time, or just forgot about it. Maybe, again, you're taking it's very possible. It's very possible. But these are supposed to be some of the better lawyers in the country who are doing nothing but this on an emergency schedule. And we're supposed to assume that they accidentally deleted this stuff and no one caught it. When journalists caught it, when legal commentators caught it, when everybody caught it who read the document, the only people who didn't were the lawyers working on the case. Now, that does happen. Lawyers can operate with blinders on when they're working on their own case. So it's certainly possible. But that's the explanation. Or the other explanation is that there was a ruling that eliminated standing. They looked at it. They said, "Oh crap, we probably can't bring these, and we're going to get hammered on them. Let's focus on the ones we maybe can bring." Okay, so that's what's to be said about this stuff with the absentee ballots, and why this is all very good from Rudy. It's just not going to really impact the case going forward.
I've never heard of that happening. I've never heard of an inspector being kept out of an absentee ballot counting, because that's the only time that you can assure the validity of the ballot. Because the minute they're separated, the ballot goes off anonymous and it's lost forever.
And real quick, I'm not going to pause this every 2 seconds. This is one of the big issues that I was pointing out before the election and have continued to point out through all of this. The real challenge, one of the real challenges the Trump campaign has in all this, is how do you invalidate a vote based on an absentee envelope? You can't trace the envelope to the ballot that was in it. And that's a big problem. That's why their remedy request is so big. That's why they're asking to invalidate entire states or entire voting precincts or voting districts. I think they can maybe narrow it down to ballot boxes, possibly. I don't know how the states particularly do that. But since you essentially look at it this way, in a ballot box, let's say there's 10,000 ballots that go into a ballot box. Well, if 5,000 of them came in absentee and weren't verifiable because no one looked at no one was there to observe the election official as they removed that ballot from the absentee envelope and put it in the scanner and went into the box. You've got 10,000 votes, 5,000 absentee votes in that box. Then what you're asking to do, since you can't go back and say, like, let's say you want to go in and challenge them later. Okay, so it's like, well, we know that these 5,000 absentee envelopes exist for half of the votes in that box. So we want to go through. Well, let's say you identify 500 envelopes that were bad. So now we've got 500 envelopes out of 10,000, 500 votes out of 10,000. They can't go in and pull out those ballots because it can't track them to the envelope itself. So now we're asking to invalidate 10,000 ballots, or I guess 9,500 ballots, because there were 500 bad ones included with those 9,500 others. That's the remedy the court is being asked to do. That's why it's such a big ask of the court, because at the end of the day, you're not asking to preserve the voting rights of one person. You're technically asking to retroactively invalidate the voting rights of the 9,500 people. That's how the court is going to look at these things. So that's where this is all boiling down to. But Rudy is pointing out a very big problem with our system. As far as challenges go, it's a good thing we have anonymous votes. So when you vote for Trump or you vote for Biden, whoever wins can't come in and somehow hack out a voter roll and figure out exactly who you voted for unless you go out and tell the world. They can't do it through the government database. So they can't just go in and start, implementing laws against people who voted against them, like despots do. We have an anonymous voting system for that very reason. Part of the trade-off of that is a trade-off in the security of the vote when we can't go in and just remove the bad ballot. Now, what should maybe happen is some sort of segregation issue where if there's a contest to the ballot, it gets segregated out, and there maybe would be if they were allowed to actually contest the ballot. So here we go.
You can never link it to the certifying paper. And things could be wrong with it, but you can't figure out which vote to cancel. So that's why so much emphasis is put on the inspection process before this became a major way of voting. That ability to inspect now becomes critical. It is our only way to assure that this new form of voting, which has been widely criticized as open to massive fraud, can be at all policed. And it has been not violated in this case, it's been trashed. It's been stepped all over. It's been disregarded here and in 10 other places, in an eerily similar pattern. And also, in the places it happens, they just all happen to be big cities controlled by Democrats, who all of a sudden have decided that you don't have a right to inspect an absentee ballot. 50 states have this rule. I don't remember this problem ever existing before. The point is, Your Honor, this is not an accident. You'd have to be a fool to think this was an accident. You'd have to be a fool to think that somebody woke up in Philadelphia and in Pittsburgh and in Milwaukee and in Detroit and in Phoenix and all the way in Las Vegas and then way back in Atlanta. And they decided, oh, we're going to shout out all the Republicans today. We're not going to let them see a single absentee ballot. And they also did it with very similar devices, like, and I can give the court and co-counsel these pictures, like all these fences that they put up. The witnesses will describe them as corrals or cages. They must have had a subcontract with a major company to get all of them in all these places. So,
okay, so my criticism of Rudy Giuliani will start here. This is a good argument, not for the initial problem that they're facing, which is standing. And they should know that they have a standing problem because they've had a standing problem in other cases that they're watching. They had a standing problem in Georgia. They have a standing problem, like I said, in the Western District of Pennsylvania. None of this is talking about how the standing issue affects their particular questions. That's the problem here. He's going straight into the facts, but he's also not arguing facts germane to the specific issues that they're questioning in court. And maybe I should bring those up real quick. Hold on. I can get them pulled up here real quick. V Bachvar. Bookvar. Okay. Go. Let me bring up this first amended complaint. Where's their first amended complaint? Petition for review file. Law respondent's brief. Hold on. Where is this document? Where did I... Okay. Let me just pull it up over here. I love losing track of my own things. Active cases. This is what I'm for. Pennsylvania. Top level professionalism. Complaint. Amended Republican complaint. Okay, so the two causes of action in this case are as follows. Like I said, we'll do these real quickly. So count one is this 14th Amendment equal protection claim. Now, this claim is actually dismissed already at the time that Rudy is making his argument. Rudy Giuliani has actually admitted at this point that this claim suffers from the standing issues of the other cases because it's brought under, or wait, is it the second one? No, the second count. Sorry. The second count here is under the electors and elections clauses. This one is dismissed before his oral argument even started. This is the one about, let's see. This is about the unequal treatment between, I think, according to the Pennsylvania Supreme Court, defendants are not the legislature, unilateral decision to create a cure procedure. Okay, so this is about notice and cure procedures that they implemented. So what they did was they created a procedure where if you sent in a defective absentee ballot, they gave guidance to counties to send notice out to the person whose ballot was defective and allow them an opportunity to cure the defective ballot. Okay? The individual plaintiffs, not the Trump campaign, but the other people in this lawsuit, they had their ballots invalidated and were not given an ability to cure. All right? So that was that's the complaint here. Now, again, this count was removed from the actual consideration of the case by Rudy Giuliani admitting that they had the standing issues that were in the other case and would not be able to do it here. They kept it in to preserve it on appeal, is what he said. So he's not arguing that there. So what we're arguing over is just denial of equal protection, which is a disparate treatment of absentee and mail-in voters amongst different counties, which relies on the same set of facts, basically, that this one is the different treatment. The other one is them creating the policy in the first place. So here's the problem, though. And this is where their standing argument is ultimately going to fail, and this is why we're talking about this. So they have two voters whose right to vote was removed, is what their argument is. Their remedy that they're asking for is to remove the right to vote for 7 million people. It's ultimately all the other noise about what is said in these arguments between Rudy and the defendants. Everything else is irrelevant to what they're asking. They're asking that these two people whose votes were removed, because of that, we need to remove everybody else's vote. Okay? All of the stuff about like absentee ballots not being able to be observed, that's a different question. It's a different question. If they brought that question, they might have been able to establish that it needed to happen, right? Like if they brought the question of, well, look, 1.5 million of these ballots couldn't be observed, and that's a violation of everything. If they had put that in the document, instead of just saying it in court, they might have been able to overturn the specific counties or precincts or the whole thing, but they didn't do it. Instead, what they said was, these guys didn't get their opportunity to cure, therefore, their votes are invalidated, so we must invalidate everyone else's votes. The proper remedy would be to allow these guys to cast the vote. Unfortunately, that's the proper remedy. Like, that's the least impactful remedy is, well, these guys were deprived of their right to vote. Get their votes in. Get them counted. So when a court is asked these two questions, do I invalidate 7 million votes, or would a better remedy be to validate 2 votes? The answer is going to be validating 2 votes. Every time. There's no way a court's going to say, and again, it's irrespective of everything else they're trying to argue because they didn't put it in the case. Evil Bunny, maybe. Only if they assert that they didn't have the thing. Yeah, you could maybe do that if you want. We don't know what the numbers are because the problem is the other problem with standing, though, is that second prong. They don't bring any facts sufficient to say that the secretary actually caused their votes to be invalidated. And so let me back this up with another effing mistake. So it's not just Secretary Bakvar who is brought here. It's several counties, right? Several counties that they want to invalidate or that they believe caused the problem. The counties that the individual plaintiffs had their votes invalidated in were not included in the lawsuit. So the people who actually did the damage to the voters aren't being sued by the voters. Let that sink in a little bit. They didn't sue the people who did it. So the court's like, why are we bringing these other people into it? And they didn't bring any evidence to actually link Bookvar to the decision of counties which didn't do the notice to cure. They didn't link Bookvar to that. So, and again, the failure to include their 2 counties in this is baffling. Baffling. Like, they could have maybe gotten to some level of standing by including those 2 counties, and they just didn't. They just didn't do it. And it doesn't make any sense.
The point that I'm making, Your Honor, is this is not an isolated case, peculiar just to Pittsburgh, Philadelphia, or the Commonwealth of Pennsylvania. This happened in at least 10 other jurisdictions at precisely the same time. Let me get to the individual plaintiffs, because in many ways, what happened to them is totally outrageous. Mr. Henry, who is in Lancaster County, voted by absentee ballot. I believe he made a mistake in his vote for absentee ballot, a critical mistake, usually, under your law, which is he failed to insert the ballot in the secrecy envelope. So the ballot looks something like this. I used to vote by absentee ballot a lot because I traveled a lot. And you're supposed to put it in an inner envelope. Outer envelope has all the information we need to see. And I've been in these contests myself in New York. They're kind of like wrestling matches. And instead of doing it this way, he unfortunately just put the ballot in without they call it the secure envelope, so that his vote can remain anonymous. So it came in. When they opened it, they quite properly disregarded the ballot, because your law is quite strict about that, as it should be, because again, this is the only way to secure the validity of these votes. His vote was discarded. Very similarly, the same thing happened to Mr. Roberts. However, in Philadelphia, in Pittsburgh, Allegheny County, in the other counties, with the encouragement of the Secretary of State, they were told to disregard that. And they were allowed to cure. They informed people that there was something wrong with their entry. And again, they're quite strict. If you leave out in New York, we call it an assembly district. I'm not sure.
He's laying out a problem, and this is backed up by an email that they submitted as evidence. The problem with the submission of the email is it doesn't say which counties were instructed to ignore it and to do it. They don't actually provide where this occurred at the direction of Bookvar. So
certain how you do it here, but you've got to have your assembly district, you've got to have your precinct number, you have to have your voter ID number, address, and you need to sign it. Any one of those things are missing, ballot's tossed. Any one. Now, in the case of Mr. Henry and Mr. Roberts, they had made mistakes. They were given no opportunity to cure. Thousands of people. And since we haven't had discovery yet, we don't know how many. Could be hundreds of thousands of people.
Could be 2.
A certain part of the state, let's call it the more Democrat part of the state, were given a very, very fulsome opportunity to cure. And we have many cases of their being told, oh, you made a mistake, redo it. You made a mistake, you didn't sign your full name. You made a mistake, you didn't put the address in. Your Honor, that's a classic violation of equal protection.
And again, he's making a very good argument that these two people's vote should be included.
I have no idea what their standing objection is. That is exactly Bush v. Gore. Exactly. If you were teaching a law school class and you wanted to give an example of a Bush v. Gore violation, you could use this as an example. They are being discriminated based on their location. In one part of the state, you can cure the ballot. In the other part of the state, you can't cure the ballot, which means they would deny their right to vote. I don't know what's more serious than being denied your right to vote in a democracy. And therefore, how they can object to standing is almost frivolous, Your Honor. Now, let's get to the campaign.
I guess it wasn't frivolous.
Unlike Wagner, which is the case that, has caused repleading of the pleadings, we're totally different than Wagner. Wagner was a harm that might possibly happen in the future. It was inchoate. It hadn't happened. This is a harm that has happened. Mr. Henry and Mr. Roberts have been denied their right to vote. Their votes have been canceled. The Trump campaign has been treated totally differently than the Bush campaign. It depends on where you are in the state. The rest of the state complied with the law and allowed observers. We have no complaints from the Republican or neutral part of the state about this happening. The only place we have it happening en masse is in the Democrat, heavily controlled counties that you can call counties controlled by a Democratic machine that have quite an impressive list of voter fraud convictions as part of their history and tradition. And all of a sudden, with this greater opportunity to do it, they did it on a grand scale. So I don't understand what the standing argument is. I don't understand how the President of the United States, the campaign, doesn't have standing to assert, if we're right, which we have to assume here, that we were treated totally differently in one part of the state, namely Philadelphia and Pittsburgh, where our inspectors didn't get to see a single ballot. And in the most of, if not all of the rest of the state, we had no problem with that.
Would have been great if you would have put it in the document, Rudy.
Just like we've never had a problem with that in 50 years. This has never been a problem before. That's an equal protection claim. Now, I believe we're going to prove it. I believe we're going to prove it way beyond even the numbers we have now. One of the problems that we have in this case and why we had to amend is because, as compared to last week, we have twice as much evidence this week. And it's not just here, all over the country. Just yesterday, in Clark County, which is Las Vegas, the election board in Clark County, which is 5 Democrats and no Republicans, reversed an election of a Democrat based on irregularities in Clark County. Those are exactly the same irregularities that we are asserting in Clark County, except he was only part of it, and we have 5 times more. So we're not bringing up a frivolous argument here, Your Honor.
He's... All right, the problem in Clark County is that they have 139 ballots that are deemed to have voted twice. Those are the discrepancies. 139 ballots, and the margin of that Clark County commissioner's race is 10 votes. So having 139 extra votes and a 10-vote spread between the 2 candidates in one particular race means a big question. That is not the same as here. It has nothing to do with here. And unless there's a whole lot more duplicate votes that they can show in Clark County, it's not going to do them any good in Clark County either. But why he's bringing up the Clark County stuff, which is completely different to the claim they're making in Pennsylvania. I guess he's just trying to show that there's a giant machine out to get them, which is fine. But they're using inconsistent methods, which to me undermines the argument a little bit. Anyway, the Clark County stuff is frustrating to me.
This is happening in all these places. We have already begun 4 lawsuits. We've got another one for tomorrow. We've got 3 others asserting just about precisely the same thing. And how this is not an injury, real, tangible, actual, already happened. And why do we come to a federal court? We come to a federal court because the federal court enforces and protects people against violations of equal protection. It protects voters who have had their vote stolen from them. It protects a candidate who, it appears, if we prove our allegations, had an election stolen in the state of Pennsylvania. And I believe in other states. Where else would we come? Where else should we come but to a federal court when we're talking about an election for President of the United States? This is not an inchoate injury. This isn't an injury that might happen. a hypothetical injury. It happened. The votes have been counted. The illegal ballots that were not inspected at all have been entered and counted. In fact, precisely 682,770 that we can count now. Last week, it was about 340,000. And probably when we get to the hearing, it'll be over 700,000. And that's only in Allegheny County and in Pittsburgh and in Philadelphia. The whole state, we're at about 1.2 million. What am I talking about? I'm talking about absentee or mail-in ballots that were entered without a single Republican having the opportunity to observe anything about the ballot. They were kept behind barricades so far away that even as to the closest you couldn't see it, you'd have no possible chance of seeing it in the back. This is absurd. I mean, this is a disgrace. This is like saying to the General Assembly of Pennsylvania, we don't care about your law. We run Philadelphia the way we want to run Philadelphia. You say we can't cure ballots? We can cure ballots. You say you have to have people present? Yeah, we'll have them present, except we'll have them behind barricades so far away they can't see a darn thing, even when they tried to do it by binocular. Isn't this ridiculous, Your Honor? This is supposed to be an inspection of something darn important. This woman's got to use a binocular? And this isn't fraud? A binocular. It's totally laughable. This couldn't happen in a neutral county that wasn't controlled by one political party, and in that particular place that has a long history of corruption.
Again, all of this would be great if they would have put that in the document as the cause of action with a proposed remedy, but they didn't.
If we have to enter those in the record, we're more than happy to show all the political corruption convictions in Philadelphia over the last 20 to 30 years. May they fill an encyclopedia. This doesn't happen in an honest place. It didn't happen in the rest of the state, which is an honest place. It didn't happen in the rest of the place, even that's democratic, but not machine democratic. This is an outrage, Your Honor, to do this to people. I have several people back here who endured it. In Philadelphia, it got nasty. In Philadelphia, we objected. We were told we'd be arrested. We were pushed further back. Several people were assaulted. Several people were pushed around, including women. And then we went to court, and we got a clarification from the court that we could be 6 feet closer. And when we came back, and we have 2 witnesses to prove this, when we came back, the gentleman who got the order forgot to bring the order with him. He told the sheriff, we now want to move 6 feet closer. We moved 6 feet closer, and they moved them 12 feet further back. Net result, 2.5 days in Philadelphia, we didn't see a single ballot. Same thing, 2 days in Pittsburgh, we didn't see a single ballot. None, 0. These people wasted 2 days of their time to be made fools of, pushed around, threatened, and when we got the order and we showed it to the sheriff said, if you move 1 step closer, I will arrest you. This is America. They're going to arrest somebody because he wants to observe a ballot to make sure that his candidate isn't being cheated in a place that is well known for cheating. I mean, he wasn't exactly in heaven. So the net result is,
stop hitting the mic.
At the point that we are at now, 338,000 in Pittsburgh, something over 340,000 in Philadelphia, for a total of 682,770. And let me correct what I said. When you look at the 7 counties, you put them all together, it's 1.5 million. 1.5 million votes that were entered illegally. 1.5 million votes that went in there, and the only person that knows if it complied with the law is a employee of a Democratic-controlled city or county. Nobody else. In many cases.
So one of the problems with this this line of argument, taking it out of the context of an election, okay? Taking it out of the context of an election and putting it into the context of any other type of lawsuit you wanted to bring, just simply saying that so-and-so is opposed to me, therefore they did a bad thing to me, is not enough in court. The fact that they know, for example, that people were not allowed to observe, there was only the Democrat Party worker, the government worker, because really it's a government employee. It just happens to be in a city that's run by Democrats. So the government worker saying, well, there was no one there to observe the government worker. The government worker, it works in a city that is predominantly Democrat. Therefore, the government worker harmed Republican person. That won't fly in any lawsuit ever. They haven't alleged a particular, or, any sort of injury. They haven't even alleged knowledge that the government worker did the thing wrong. And so this line of argument is relatively weak. Now, the only fallback for them is that there's supposed to be a requirement to have the person there. But the problem, again, comes with they don't have any communications linking, Bookvar to these particular workers, telling them to keep the people away. They don't have any evidence of that. They have the inference of evidence, like he said earlier. Of course, no one just woke up in all of these places and told these people to do this. And of course, that doesn't make sense that would happen. But maybe it did. And you haven't alleged that it happened otherwise. And that's a big problem with the argument that they've got.
Even Democrats weren't allowed to see it. Democrats weren't allowed to see it because they couldn't count on the fact.
If Democrats and Republicans are both excluded, you just eliminated your equal protection claim.
But all Democrats are crooked. They're not. A decent Democrat seeing this would have said, what the heck are we doing? In fact, one in Detroit did do it and is a witness for us. She was so disgusted by the process, she came and reported it. So they made sure it stayed with their little mafia, who would be nice and quiet about it. They didn't let a Democrat see it. They didn't let a Republican see it. Nobody got to see it. Completely flaunting the law of Pennsylvania, but even more importantly, completely, and that's why we want the due process count back, completely violating what has been universally recognized as a thing of fundamental fairness with these ballots.
That's why we want the due process claim back. That's him referring to the fact that their due process claim regarding the people being removed or not allowed to observe was inadvertently removed from the petition. Very inadvertent. I'm sorry, I have trouble believing the inadvertent part until it was, I don't know. Maybe it was inadvertent. Maybe it was. If it was real bad lawyering, that may have cost Trump the election.
Every state in the union has an inspection requirement. That's not by accident. And if it didn't have an inspection requirement, now that a third of our vote is being counted by absentee ballot, well, you got to have one. But you don't just have to have one. You have to have one that you're going to enforce. If this is allowed without serious sanction, meaning the canceling of these ballots, this would become an epidemic.
Okay, another issue in this case that I should probably explain. This isn't a Rudy thing. This is in regards to what they're arguing about, though. The notice to cure, right? The notice to cure, that's the equal protection argument that we're going over right now, is in some counties you were allowed to cure, in other counties you weren't. The problem that they have is that the court case, which was the Democratic Party of Pennsylvania versus Bookvar, in that court case, they ruled that they were allowed to do a notice to cure. But there was no ruling in that court case that said that every county must do a notice to cure. So it was basically may versus shall. county may implement a system, provide notice and an opportunity to cure. It was not shall. And so since it's permissive, they've got another problem here. Is it equal protection if every county had the opportunity to adopt this but didn't? That's a different sort of thing. It's not that Philadelphia was allowed to do the thing and other counties weren't allowed to do it. All of them are equally treated. All of them could have implemented the process. All of them have the opportunity to legally do the same thing. Then the question becomes, why didn't they do that? And if they didn't do that, you then have to establish that they didn't have to do that for an unequal reason rather than the individual county's own discretion. Okay? So you would have to make the argument that Secretary Bookvar, for example, sent out directives only to specific counties to tell them to implement notice to cure, and then sent maybe directives to other counties to tell them not to do that or something. You have to find a way in which the actual treatment is unequal rather than just courts choosing a different thing. Because if you want to get into it, like how far that equal protection argument can go, because I know it sounds unequal to say that some can, some can't. Well, when you look at how equal protection plays out in elections, counties can have X amount of polling stations. Does that mean every county needs to have the same amount of polling stations? No. Does it even mean that every county even has to have the same amount of per capita polling stations as other counties? No. So we can't just say that because things happen a little bit different in the counties, that it's automatically a violation of equal protection if they're permissive and some counties do not choose to adopt them. This is the problem with the legal argument here and why they need more. At the end of the day, they need more, and they need to link it to a nefarious act, and they haven't done it.
I mean, you give them an inch, they're going to take a mile. They've already taken a mile. They take a mile, they're going to take a whole city.
That was an old man realizing his analogy didn't sound very terrifying and fixing it on the fly. That was great.
This cannot be allowed. And what did they steal, really? Well, they stole an election, at least in this Commonwealth. These votes are way more than enough to overturn the results of the election. And one of the questions in Wagner was, did they have enough votes to overturn the results of the election? We have 10 times more votes than we need, and we're still getting complaints. It would overturn the results of the election. So this is a real controversy. This is a case, and it's a controversy. And I don't know, since I went to law school, that's always been the simple test for whether you have standing. And I really do believe their argument on standing.
That's not the test for standing. That's not having a case or controversy. This is a case, this is a controversy, is not a standing argument. That is oh. Well, do you have a case or controversy? Well, yes, because we have a case and we have a controversy. No, it's the 3-part test I disclosed earlier. You have to have an injury in fact. You have to have the injury being traceable to the defendant, and you have to have the ability for the court to provide redress. That's the standing argument.
It's just an argument to delay this, because they'd like to delay this as long as possible. It's certainly a frivolous argument, Your Honor. Your Honor, I ask the court to allow us, first of all, to deny the motion to dismiss so we can quickly move to starting to put before you the proof that we have. We have hundreds of affidavits, Your Honor. The question here is going to be, if we proceed to a hearing, if that's your decision, the question is going to be, how do we present that evidence without burdening the court? I mean, a lot of it is repetitious, but repetition proves it over and over again. I'd say we have 300 either affidavits, declarations, or our own statements that we've written down that will be subjected to the process of affidavits. And we do have, in addition to these pictures, which I'll submit to the court, should I mark them as an exhibit, Your Honor, or?
You're welcome to do so. Mr. Don.
Notice this isn't an evidentiary hearing. The evidentiary hearing was actually scheduled for 2 days later. Rudy's attempting to introduce evidence here. That's why the judge is kind of like, what? I mean, I guess. So he's gonna present some pictures from Pennsylvania polling places. Presumably, he actually doesn't know, and that's kind of embarrassing. That's coming.
Donovan and defense counsel, we had an opportunity to see.
Sure. No, they haven't. I'm going to give it to them now, Your Honor.
Or have copies of them available.
I haven't, Judge, and I don't believe they're part of the complaint. I have no objection to looking at them, but I'll get to that when I see them.
No, they aren't, Your Honor. They're in paragraphs 132 to 149, we allege this.
Well,
Okay, so can I mark this?
Let's go back to that, but if you can supply a set to Mr. Donovan, and what are the paragraphs of the complaint? 132 to what did you say?
I believe it's 132 to 150.
Thank you.
So
let's continue your argument. We'll
That's the paragraphs about the preventing poll workers and poll observers from actually being able to meaningfully observe, meaningfully be present when absentee ballots and other ballots are being counted. This is a good claim. This is the one that is, those are facts asserted, but they're not actually articulated in a claim in the lawsuit.
get to
I'm just at about the end, Your Honor. So I'll mark, just so that we're clear at what they are. The first one is a picture of the center in Philadelphia, where the woman appears to be 20 to 30 feet away from the closest counting area, quite obviously unable to see anything of significance. So I'll call that Exhibit A and give it to co-counsel. And I used to be a clerk, Your Honor. Hope I'm doing it right. I'll make it Exhibit A.
Yeah, so far so good.
Oh, in case I need a job after this.
You might.
This is Exhibit A. Again, a second picture to show how far away they were. I mean, and as you might imagine, there was very serious objection by these people to this. The whole day was wasted, standing there like potted plants. The first two, A and B, are Philadelphia. Here you are, sir. Thank you. And the second two, which we'll call...
In Rudy's defense, this is the worst part of a hearing, is like doing this song and dance about adding exhibit numbers and handing it out. I hate it. It's just awkward and it's quiet and it sounds really weird on a recording. So, the thing is, he's getting like stickers and putting them on the things and filling them out. And that's why he's trying to break it up with humor because it's really boring and disruptive.
C is a young woman having to use a binocular to try to see. As you might imagine, it didn't accomplish anything. She wasn't able to see anything. Largely because the ballots are here, you can't find them. There's C. That's Pittsburgh.
Sir, Judge, may I have a representation from counsel that A and B, as a kind of officer of the court, is Philadelphia?
I was told that.
Well,
That's my understanding, sir.
okay.
If it isn't, I'll correct it.
So Mr. Giuliani's representing that what are proposed to be, what have been marked and are proposed as plaintiff's exhibits A and B are from Philadelphia County. I think Exhibit C, he's indicated is from
Allegheny County. And the last one, Exhibit D, is also from Allegheny County.
He doesn't actually know that. He just got these pictures today. It doesn't matter in the long run, but...
And since I just got these coming here today, I will check, and if they're different counties, I'll correct it, Your Honor. So again, in conclusion, Your Honor, we would ask you to deny the motion to dismiss so that we can, as quickly as practical, move to the part of it where we can present the evidence so that we can show you that what we are alleging, which you have to deem to be true now, is in fact true. and that we can establish it and prove it with witnesses, photographs, videos, audios, and expert witnesses.
Ooh, audios.
Very good, sir.
Thank you, Your Honor.
Thank you. Ms. Kearns, Mr. Scaringi, you have anything to add by way of at least initial argument before I turn to the defense?
No, Your Honor. As you know, I filed a motion to withdraw with the agreement of my client, and I defer to the new counsel's strategy.
Thank you. I know that, Ms. Kearns. I didn't act on that. I let Texas counsel withdraw last evening. I wanted you here because I had some specific questions that I'll circle back to later. But I thought you, since you've been involved in representing the Trump campaign from the beginning, might best be able to answer. You are welcome if you are not able to answer those questions, or if you prefer to defer those questions to Mr. Giuliani and Mr. Scaringi, you're welcome to do so. But I wanted to have you here today because I had some questions specifically that I thought specifically you could answer.
Get on with it!
Absolutely, Your Honor. I'd be happy
Get
to
on with
answer
it!
anything that you ask.
Very good, thank you. Mr. Scaringi, anything to add to Mr. Giuliani's argument?
No, Your Honor.
Thank you.
Your Honor, may I just also point out that Linda is going to be representing the campaign and Donald Trump in the state court actions.
Understood. Thank you.
Continue to be part of the team, but not just on this particular.
Understood.
I have continuing cases in both the Supreme Court and the Commonwealth Court that I'm handling.
Very good, Ms. Kearns. Thank you very much. All right, Mr. Donovan, I'll turn to you next.
Thank you, Your Honor. May I use the podium?
If you prefer, that's fine.
I do. Thank you.
Okay, so that was Rudy's part. I've said my criticisms of it. It would have been a good oral argument, or a better oral argument, if it would have been related at all to the issue, or if they would have put in a relating issue in their actual filing, but they didn't do that. So that ultimately is a big cause for the dismissal. It's also a big problem. I want to reiterate that this is a big problem because I know people are like, oh, well, it's going to go to appeals, it's going to go to Supreme Court. Fine. The Supreme Court most likely is only going to be hearing these two counts. This equal protection denial for disparate treatment of absentee and mail-in voters among different counties, and then the violation of the Electors and Elections Clause relating to the ability to even create a notice to cure that they say that they couldn't do. Okay? Those are the two issues. No other issues are actually raised in this complaint as issues with remedy and redress for the court. Therefore, they will not be able to bring new issues to the appeals or Supreme Court. They can't. So all of the stuff about all of the mess in Pennsylvania regarding their not allowing people to observe the absentee ballots, those can't be brought to the Supreme Court under this case. Can't do it. The only way to get them in would be to object to the district court's refusal to allow them to hear or to amend their pleading. And that's going to be tough. Very, very tough for them to do. So at that point, but until then, they're going off of these two issues. The remedy is very steep. Now, the Supreme Court may do it. We'll have to see. Oh, God, come on! Oh, wait, I'm going to skip forward a bit because this idiot's going to set up a projector.
Some extras for people.
Yeah, that's fine.
I gave some here.
Mr. Giuliani, you have a copy of...
I do, Your Honor.
Your Honor, Daniel Donovan for the Secretary. And let me start on behalf of the Secretary to thank you for all the efforts and your staff. I know you went through to have us here live. I think that's important. But I also know it's a difficult task. So on behalf of the Secretary, thank you. The November 23rd deadline for county boards to certify the election results are fast approaching. And the Secretary and her team are working to certify the election results of the over 6.8 million votes cast here.
Wait a minute. Didn't you guys say that Michigan certified? Didn't that happen? Michigan certified the vote? Well, how could that have happened? I thought the Wayne County Republicans rescinded their certification. Remember?
In the Commonwealth of Pennsylvania. I know you've received a tremendous amount of briefing. I intend to do my best to distill the arguments rather than repeat them. A couple observations. Let me start, Judge. I am going to focus on the First Amendment complaint filed by the plaintiffs. Much of, I think, counsel on the other side of the aisle focused on allegations that are not in the complaint. In fact, the Canvas Watcher allegations were deleted out of the amended complaint. And the plaintiffs were kind enough to provide a red line version, so those claims are out. But I'm going to focus, Judge, this afternoon on the motion to dismiss standard. Okay. So let me start and address what this case involves and what this case does not involve. And just for ease, for those that have a hard copy, I'm on page 3 of the slides. So at this point, we have a single count, a federal constitutional equal protection claim. And the plaintiff's factual predicate in the First Amendment complaint can be distilled into a challenge to 3 election code practices, Judge.
Right off the gate, this guy is kicking Rudy Giuliani's butt. and the reason he's doing it is because he's arguing straight out the gate over the issues that are before the court. Rudy talked about a grand sort of narrative that he was weaving. It was wonderful that he did that. It was very red meaty for supporters. But what this guy is doing is talking about, look, we have one controversy before the court. We're going to address the arguments. Here's how we're going to go about it. His speaking style is very clear, very concise, and very issue focused. And when you've got a complex or really a big case like this, I mean, I know Rudy's going for like this sort of outrage, these people's votes, blah, 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 blah. What he's trying to do, but really, like, you've got to actually nail down the factual basis for what you're doing there in the first place.
First, plaintiffs allege that certain voters were permitted to cure deficiencies to their mail-in ballots before Election Day. That's one. 2, plaintiffs allege that certain voters were apprised that their mail-in ballots were defective, and some of those voters elected to vote a provisional ballot on Election Day. And of course, I know Your Honor knows, but so others know, provisional ballots go through a process. They're reviewed pursuant to the Pennsylvania Election Code that involves a public process before county boards, and then they can be challenged in state court if there's any challenges to this. So that's 2. And then number 3, Your Honor, is plaintiffs allege generally that certain mail-in ballot envelopes were not filled out consistent with the Pennsylvania Election Code, and unspecified counties should not have counted those, although they allege generally some might have. Those are each the 3 practices that are alleged to be violations of the Pennsylvania Election Code, and that is, under state law.
Now, he has framed the argument. Rudy never did, and so this framing is what's probably, like, this is a side, just sort of a strategic point. He framed the argument for the judge very nicely. Rudy never did. The judge doesn't have to think between 2 framings or choose because this guy did it for him and Rudy chose not to. So again, stylistic questions. This is not substantive. It's just tactical.
Plaintiffs argue certain ballots should not have been counted. That is the basis in the complaint for the equal protection claim. I believe it's just as critical to summarize what's not in the complaint. There is no claim in the complaint that any qualified Pennsylvania voter cast more than 1 ballot that was counted. There's no claim that any qualified voter who submitted a mail-in ballot had his vote wrongly rejected. There's no claim that anyone not eligible to vote in fact voted. And there's no claim of voter fraud that affects the equal protection claim. That's not in the First Amendment complaint.
And that was critically brutal. There's no claim that anyone's vote was wrongly removed. That's the problem with their plaintiffs right now. The plaintiffs' votes were properly rejected under Pennsylvania law. There's no claim that anyone's vote was improperly done. There's no claim that anyone voted twice. What were the other two? Shoot, let me go back. This is a good section.
Pennsylvania voter cast more than one. There is no claim. I believe it's just as critical to summarize what's not in the complaint. There is no claim in the complaint that any qualified Pennsylvania voter cast more than one ballot that was counted.
Okay, so no double votes.
There's no claim that any qualified voter who submitted a mail-in ballot had his vote wrongly rejected.
No votes wrongly refused, only properly refused.
There's no claim that anyone not eligible to vote, in fact, voted.
No claim that any felons or non-residents voted. They haven't brought any of that.
And there's no claim of voter fraud that affects the equal protection claim. That's not in the First Amendment.
No voter fraud. Fraud. That's the Asian version of voter fraud. There's none of... I'm just kidding. I'm kidding. Oh my goodness. They shouldn't let me drink during the day.
Complaint. So to be sure, all qualified Pennsylvania voters have an equal right to vote. Every voter in every county, including voter plaintiffs here, had the right to vote either in person or by mail. And there's nothing unequal about the ability to cast a vote in this case. And I'm going to get to some of the cases, actually, that talk. I know one of yours does as well, Your Honor. But at the end of the day, this case is about a claim that a very limited number of qualified voters had their votes counted. In fact, counted when plaintiffs argue under state law, they should not have been counted. As relief, the plaintiffs ask, Your Honor, to enjoin certification of every ballot in the state of qualified electors, and they do that by alleging that some state officials did not follow the code. That's the allegation.
Again, he summarized it, and rather neutrally there. This is, again, good boy points for this guy. He says their only claim is that some votes were counted. Now notice he says some. They say a lot. He says some votes were counted that should not have been counted. And he says that because of that, it's because some officials didn't follow the rules. Okay, so he has framed out the issue.
That's not an equal protection claim. I'm going to walk through that, Your Honor. No federal court has ever recognized that theory. And anything other, I submit, than counting ballots lawfully cast by qualified Pennsylvania electors is not only against the law, I submit it's un-American, but it certainly is not a federal constitutional claim. So now, Judge, let me turn.
And part of this is to say that this case should be in Pennsylvania state court. That's one of the issues here as well. This is, it's not being said specifically, but really, when we think about this, they're trying to make this into an equal protection claim to get it in the federal courts when it's really a Pennsylvania state law claim. And I don't know how else to say it. It's really a Pennsylvania state law claim. They don't want it in Pennsylvania state courts because they're going to get smoked in the Pennsylvania Supreme Court. That's how they're going to do it. They've already lost their, 5-2? Because it's 5 Democrats, 2 Republicans. I mean, they know they don't have a good shot in the Pennsylvania state court. They're trying to make this into a federal issue. But really, all the issues they're talking about are pretty much Pennsylvania state issues. And they lost on those cases.
Actually, if you just go back to slide 2, I had them a little backwards there. These are the 4 issues we're going to address this afternoon. First, Judge, is the lack of standing by any of the plaintiffs to pursue their equal protection clause. This jurisdictional defect, most recently made clear in Bognet, as well as Your Honor's case I'll get to, remains fatal to the plaintiff's claims even as amended. That's 1. 2, plaintiff's claims fail to state an equal protection claim pursuant to 12b-6. Plaintiffs attempt to create a federal constitutional equal protection claim when what they are challenging are state law practices. We're going to show that doesn't establish, even at the motion to dismiss stage, an equal protection clause. Third, Mr. Aaroncheck, once I pass the I guess, the virtual podium to Mr. Aaroncheck. He's going to address abstention and the final arguments, and I understand some other counsel may have some other points for Your Honor. So let me start with standing, Judge, and for that, I'm going to turn to slide 5. Judge, plaintiffs lack standing to assert the equal protection claim, and I would submit to the court there's 3 cases I'm going to focus on. First is Your Honor's case, the Pennsylvania Voters Alliance from October, Your Honor's decision on standing there. Second, the Bognet decision that followed yours. And then third, Judge Ranjan's decision in the Western District of Pennsylvania with the same plaintiffs who made equal protection theories there. That's what I'm going to focus on, Judge. And because I went through your opinion, and as Your Honor says about standing, Article 3 of the United States Constitution limits the power of the federal judiciary to cases and controversies. As I've heard it said, federal courts have immense power, but limited jurisdiction. And this is what you go on to say when you say it's an irreducible constitutional minimum to address that. Your Honor then goes through the law on standing for particularity, speculation, causation, and redressability.
If you haven't caught what just happened, and again, this is a brutal oral argument from the other guy, especially in the face of, and this is the sort of football play of court. Rudy Giuliani brought his play, and this guy picked a counterplay, and he picked right, and Rudy picked wrong. Rudy went for a grand narrative. This guy went for an analytical point-by-point thing. As part of that play, what he's doing right now is he's going to read the federal standing issue from an opinion written by this judge. He's going to lay out the requirements for federal standing as articulated by the judge he's standing in front of. And it's bad for Giuliani.
So I don't intend to repeat the law, Judge. I know it's in your opinion, but I want to apply these facts to it. So the plaintiffs in the First Amendment complaint, Judge, on standing are actually quite limited. They argue some qualified voters were able to cure their deficient mail-in ballots or vote provisionally when they found out their mail-in ballot was deficient. The only specific allegations they refer to are to Philadelphia County in the First Amendment complaint. There's nothing as to 6 other defendant counties, and there's nothing as to the other 60 counties in the Commonwealth. And these allegations, I'm going to show under settled case law, do not establish standing for the individual voters or the campaign. In the end, Your Honor's case, Voters Alliance, Bognet, and the Trump campaign versus Book Bar in the Western District all lead and support dismissal based on standing. So I want to turn to Bognet, Judge. Bognet faithfully applies these principles, as you know, Chief Judge Smith wrote for the Third Circuit. And he explained, this was a quote at star 6 of the Westlaw. If the injury you claim is an injury that does no specific harm to you, or if it depends on a harm that may never happen, then you lack an injury for which you may seek relief from a federal court. And I'm going to show you the plaintiffs fail to assert particularized concrete injuries under the law. And why is that? Well, the premise of the plaintiff's...
He's actually wrong here. Now, he's making the argument, but this is the one place that they do actually establish the first element of standing. They do, with regards to the 2 voters who had their votes removed. Okay? It's pretty simple. They had a right to vote, and their right to vote was infringed because their vote wasn't counted. So they did establish an injury. Now, this is, if you saw my doom pilling on Lynn Wood's garbage lawsuit in Georgia, this is a different. Lynn Wood failed at the first element of standing because he didn't articulate a particularized injury. And they may sound the same here because you go, wait, Lynn Wood's right to vote was implicated. These people's rights to vote were implicated. That's the same thing. Why does one win, the other doesn't? Lynn Wood's argument was not that his vote wasn't counted. That's what the argument is here. These people's votes weren't counted. So they have an injury. Their right was removed. In Lynn Wood's case, he argues that his votes were diluted by the inclusion of improper other votes. So his right to vote wasn't actually removed. He's just saying that other votes were counted, therefore diluting the power of his own. The problem with Lynn Wood is that everybody in Georgia's rights are diluted an equal amount when they're per vote cast. So he doesn't have a particularized injury. These guys are particular because not every voter had their votes removed. I mean, if every voter had their vote removed, maybe they would have a particular injury in that case, because it does say that if an injury to a fundamental or personal right exists, it doesn't matter how many people it affects. So when you have the removal of a right, such as the removal of a vote, you do have an injury in fact as far as standing goes. When you have the dilution of your vote, that is the same as the dilution proportional to every single other similarly situated voter in a state, you don't have a particularized injury for standing. It's a subtle distinction, but it's really, really important.
Challenge is that certain allegedly invalid votes may dilute, I think that's what Mr. Giuliani was talking about, may dilute other votes that they believe were validly cast in the state, Commonwealth.
The court, I don't think the court even addresses that argument, because they do find an injury in fact because their plaintiffs' votes were removed entirely. So they don't get to the dilution argument, but that is the issue down in Georgia.
But that's not a concrete and particularized injury under Voters Alliance, Bognet, or even the Trump case from the Western District. The injury is not particularized to the voters or to the campaign. And I submit Bognet squarely forecloses plaintiffs' attempt to manufacture that claim. And I'm going to show you some of the pieces of that now, Judge. In Bognet, as you know, the Third Circuit held that the plaintiffs lacked standing to bring Equal Protection Clause claims alleging vote dilution because such harm was neither concrete nor particularized. Specifically, the court held counting ballots in violation of state law is not a concrete harm under the Equal Protection Clause. They could challenge in state court, as Ms. Kearns is doing, but it's not an equal protection clause under the United States Constitution. And the court further held in Bognet that the alleged counting of improper votes is a generalized grievance that is insufficient to confer standing. And here, Judge, I know you've looked, but if you look again at the First Amendment complaint, it boils down to allegations that the election code was not followed in certain instances. Well, Judge, if you turn to slide 6, if you would, I put a piece of Bognet up here. In the Third Circuit, writing, a vote cast by fraud or mailed in by the wrong person through mistake or otherwise counted illegally has a mathematical impact on the final tally and thus on the proportional effect of every vote. But no single voter is specifically disadvantaged. Such an alleged dilution is suffered equally by all voters and is not particularized for standing purposes. And Judge, the sole equal protection claim in the First Amendment complaint boils down to a claim that some, but not all of the defendant counties counted mail-in ballots with some facial defect in them, or they should not have been counted. Nothing more is left in the complaint, Judge. And Bognet, I submit, holds plainly that plaintiffs do not have standing to assert those votes, or to challenge those votes that arguing they were diluted under federal law. Whether the equal protection claim is predicated on unlawful counting, as they allege, or counting ballots that were corrected, Chief Judge Smith's analysis in Bognet confirms that plaintiffs lack standing. And in both instances, the allegations amount to a generalized grievance that the Pennsylvania election code was not followed. Every citizen has an interest in the proper application of the election code, and plaintiffs have no concrete particularized and non-specific. And the source of these allegations.
This is a very frustrating aspect of legal reality, to be clear. This doesn't make logical sense. So what he's reading from is he's reading from this other decision, and it's talking about how, look, if the state just doesn't follow the law and it screws over everybody, well, that's just too bad. You don't have standing to sue the state because everybody got screwed over, not just you. If that sounds like it's a heap of trash and illogical, that's because it is, but it also is. And it has been forever. So it's not new. It's not a surprise. But it does suck.
It's a matter of state law, Judge, which makes any alleged harm abstract for purposes of equal protection. The plaintiff's only basis for allegedly dilution from the unlawful counties is the election code. That's not a concrete harm. Now here, plaintiffs allege that some electors were treated unequally, but that's not a particularized harm to them. It's a generalized claim, again, Judge, that the Pennsylvania election code was not followed in certain instances. And here, Judge, I go to slide 7. This was again addressed in Bognet. On the issue of standing, Third Circuit held, precedential decision, the logical conclusion of the voter plaintiff's theory is that whenever an election board counts any ballot that deviates in some way from the requirement of a state's legislatively enacted election code, there is a particularized injury, in fact, sufficient to confer Article 3 standing on every other voter, provided the remainder of the standing analysis is satisfied. But allowing standing for such an injury strikes us as indistinguishable from the proposition that a plaintiff has Article 3 standing to assert a general interest in seeing the proper application of the Constitution and laws, a proposition that the Supreme Court has firmly rejected. And that's what we have here, Judge. The campaign's argument is no different. The campaign argues that the counting of alleged cured ballots or provisional ballots, but it would not affect the campaign in a particularized way. And why is that? Because the ballots that are being counted are for all races on the ballot, federal and state. I know sometimes we only focus on certain races, but the ballots, as Your Honor knows, for all federal and state elections. And for whoever that voted for, all candidates in state and federal races were subject to the same rules. And Judge, it's not just in this circuit. I would direct the court's attention to slide 8. This
Slide
was in
8.
Hotz v. Hollins. Again, this was a voting case, recent November 2nd, 2020 from the Southern District of Texas. Here they said the plaintiff's general claim that Harris County's election is being administered differently than Texas's other counties does not rise to the level of the sort of particularized injury that the Supreme Court has required for constitutional standing in election cases. And Judge, that was a case relating to Harris County had that drive-through for COVID, you could drop off your ballot, but no standing there. So in the briefing, Judge, there was some...
That Harris County case was a case Republicans won, by the way. So this guy is picking cases. Note what he's doing is very effective. He's giving a very neutral analysis, very analytical, and he's also picking cases that favor the presumptive opposition whenever possible. Uncivil law says, down here, salt is a way of life. The ceiling is salt, the floor is salt, the walls are salt, and to an extent, the air is salt. And you breathe that in, and you constantly taste the salt. It's a salty kind of day, isn't it, buddy?
allegations that plaintiffs, that they were denied the vote, okay? But plaintiffs don't actually allege vote denial. And let me start with the two voters. If the concern of the voters was that their vote was denied, they would have sued their own counties, Fayette and Lancaster County.
Yes.
They're not defendants here. The defendant counties in this case did not in any way deny those two plaintiffs their vote, nor could they. They're not voters in those counties.
Why didn't you just include Fayette and Lancaster counties, you idiots? Why didn't you do that?
Counties. Their home counties did not count their vote. And according to the plaintiff's allegations, they admit they did it wrong, and they should have. And the request of relief in this case is to stop votes of people in other counties. And
Again, under the case that they brought, this sounds ludicrous. Wait, Fayette and Lancaster County screwed up, so let's not count the votes of Philadelphia? Why? This is what a judge has to ask these questions, and is why this case is such a problem.
under standing case law, they don't have standing to assert that. It's generalized. And that goes to slide 9, Judge. We now go to, well, can the candidate sue for that? in federal court under the U.S. Constitution, not Pennsylvania law. In slide 9, bogging that says, for a candidate to have standing to enjoin the counting of ballots arriving after Election Day, such vote would have to be sufficient in number to change the outcome of the election. And we heard numbers today and pictures, Judge. I don't have everything. I'm just a lawyer, Judge, but I looked at the complaint, and none of those numbers are in there, Judge. And that's what I show on slide 10. What is not alleged in the complaint does not allege which counties publicized the cure process, whether voters cured their original ballot or cast a provisional, whether any such county has cured any provisional ballots, and whether such counted ballots were cast for President Trump or anyone else. And Judge, this goes to plaintiffs' alleged injuries that are speculative. These speculative injuries cannot give them standing in federal court. In federal court.
This is the problem with federal cases require you to state with some level of particularity. This is a claim, and a speculative claim isn't enough. They have to say this happened. They don't have to prove it. They basically just have to allege it. Okay, this many votes were flipped and caused this. About this many votes in this county were flipped and caused this. They don't have it. And yes, it's hard to get that information. I'm not ignoring that. But it being hard is part of the problem. It's part of the, I shouldn't say the problem, it's part of the issue with bringing a case in federal court in every single instance. This goes back all the way to Bell Telephone, right? Bell Telephone. Some guy said Bell Telephone was out there with AT&T and they were coordinating. I think it was AT&T and Bell. They were coordinating and engaging in uncompetitive practice where they would carve out different cities and only one phone company would go into a city and then the other one would just by gentleman's agreement go into a different city and they wouldn't compete with each other. Were they doing that? Of course they were. Of course they were. They still do it to this day. The problem was, in that case, the guy couldn't point to a single alleged communication between AT&T and Bell. They couldn't do it. He couldn't say, you know what, on September 8th, there was a meeting on a golf course in Malibu where the two CEOs got together and decided this. On information and belief obtained from a caddy. They couldn't do anything. They could never allege any communication between the two. So they didn't have standing there either. Or, well, they failed to state a claim, but basically the same thing. They couldn't articulate how an injury was caused unlawfully. That's what's happening here. They assume that because some ballots were counted incorrectly, or were removed out, that there must be some that could be overturned. Here's what they haven't done. And they probably can't. So I'm not saying that they should be able to do this. They haven't calculated up how many ballots are actually suspect. They haven't done that. They haven't gone through and said, well, this many ballots would be suspect. So they, just an issue with the pleading. And again, this is not a particular criticism of Trump's team. Oh my goodness, I'm getting texts and they just won't be quiet. Let me see if I can stop that real quick. Nope. Let me close this out. It's not a criticism in this case of Trump's team. It's a practical reality of federal lawsuits. And it's really, really tough to get around in election cases. This is why, again, before the election, after the election, I was saying, I don't know about these lawsuits because it's really hard to do this. It's a really hard thing.
The campaign does not allege the issues they raise in the amended complaint would change the outcome of the election. I heard from counsel this morning, but that's not in the complaint, Judge. There are no such allegations. Now, they do argue they'd like discovery to find facts, But, Your Honor, I've been before you before, and I know that under the rules and the understandings, plaintiffs must make allegations that survive dismissal before discovery.
Yep.
And finally, there's no sufficient allegations of an imminent injury that they allege. They advance specific allegations regarding Philadelphia County in the complaint. That's at paragraphs 127 and 128 related to their equal protection claim. And there they allege that Philadelphia County allowed certain voters to cure ballot envelope defects by casting provisional ballots. But plaintiffs don't allege whether those voters actually cast such a ballot or that Philadelphia counted those ballots. And this is what I think, Judge, is the death knell in the motion to dismiss it. There's no allegations about any other county then. And there's nothing related to the other 60 counties in the Commonwealth. It's just speculation. So let me wrap up standing, Judge. I come back to the trinity of cases. Your Honor's Pennsylvania Voters Alliance from October, Bognet from recent, and then the October decision by Judge Ron John in the Campaign versus Bookvar. All three found lack of standing, all laid out the law, and all foreclosed standing in federal court to address these issues. And why is that? The two voters, Mr. Roberts, Mr. Henry, they allege vote dilution. They're not challenging their own counties. And a general grievance that counties should follow Pennsylvania election code and not count other votes is not permissible in federal court. And Your Honor, I just covered for the campaign, there's no vote denial. The campaign's not a voter. But they don't have standing. There's no vote dilution standing because the allegations they assert under Bognet and the progeny don't provide for standing for these allegations. That's not an unequal or competitive disadvantage under Bognet, whether valid Pennsylvania electors were able to get their ballots to be counted. So, Judge, I'm going to stop on standing, although I'm happy to answer any questions as I go, Judge, but I'm now going to turn to the equal protection claim. That's slide 11, and I'll go to slide 12. But let me start on the equal protection claim. So on standing, Judge, I just want to say, I think that's the place to stop, Judge. I think that's what it is. There's challenges in state court, and no one's trying to stop any state court, valid state court. But here in federal court, we have limitations, and I don't believe they've satisfied it, Judge. That's step one.
So the other path to the Supreme Court is through the state court. If they get to the Pennsylvania Supreme Court and are shut down, they can appeal to the U.S. Supreme Court if they can raise a particular question out of the Pennsylvania Supreme Court's failure to rule. But typically a state Supreme Court is going to have the final say on state law. That's another path to the Supreme Court. It's a much less likely path.
But I don't want to interrupt your flow of argument. But
Please.
With regard to and Mr. Giuliani and Ms. Kearns can answer this question as well. But just to orient me, how many matters are pending in Pennsylvania state courts, and if you know, which common pleas courts are impacted?
Yeah, so the one I'd start with is in the Pennsylvania Supreme Court currently is the issue that Mr. Giuliani and Ms. Kearns referred to about whether a canvas under state law is at 6 feet, is it 12 feet, that issue.
And that's an appeal to the Supreme Court of Pennsylvania?
Yes, it's currently there. There also have been, and I know Mr. Aronchek was part of these, so he could probably hit these better. Some in the state courts have already been adjudicated. And that's where Mr. Aronchek's going to make the point. There's abstention issues. There's Rooker-Feldman issues. They've been litigated. And there's some ongoing that Mr. Aronchek can, because he's involved in it.
Can he better answer that question?
Yes, he can on the common pleas.
That's fine. Let me defer those questions to him. I assume he'll answer them as part of his argument. All right, go right ahead, answer.
Okay, but that I
What? It's still running. It's just silent for some reason. Whoops. See if it comes back.
it must
Oh, there we go. They must. Something got silenced out. I don't know if it's.
and it must be dismissed,
intentional
Judge,
or
if you
not.
get to it, because it fails to state a cognizable claim. And again, I just want to emphasize this because it is the current complaint. The plaintiff's claim is that certain counties permitted voters to cure defective mail-in ballots and have those votes counted, and that certain ballot envelopes were not fully filled out but were counted. This alleged violation of state law, simply under the cases I'm going to go through, cannot establish a federal equal protection clause. The amended complaint continues to try to create a constitutional claim out of what's called, I think in both Your Honor's case and other cases, garden variety election practice disputes. And now, Judge, I'm going to refer to Judge Ranjan's. There's two cases. There's what is the campaign versus Secretary Bookbar from earlier this year in the Western District. And in that, Judge Ranjan held that garden variety election irregularities are simply not a matter of federal constitutional concern. And Judge, this is slide 12 for those. It's not a matter of federal constitutional concern, even if they control the outcome of the vote or the election. And that's at star 49 of the Westlaw site there, Judge. And the plaintiff's allegations about notice and cure do not state a constitutional claim either. The claim does not involve any persons who are not qualified Pennsylvania voters in the Commonwealth. Instead, plaintiffs allege that certain qualified voters were given notice, or they figured out that they're mail ballots, because you can go online on the SURE system, and it says whether your vote is canceled, and they might have come in and voted provisionally. And again, I want to stop here. Both under federal law and Pennsylvania election code, if a voter shows up at a polling place and says, I want to vote, even if the poll book shows that they've already voted, they have to be provided a provisional. And what that means is that then gets figured out later. That goes through the provisional process. So that's the allegation here. Well, so what's alleged? Well, instead, plaintiffs allege in the amended complaint, they don't even allege that any county even counted any such cured ballots. The provisionals, remember, they're going through the process. The amended complaint, again, I come back to, they only allege that there was a cure process with respect to Philadelphia County at paragraphs 127 and 28. And the plaintiffs offer nothing as to the other 6 defendant counties and offer nothing as to the other 60 Pennsylvania counties. So let's turn now then, Judge, to what do they allege? Well, the plaintiffs do not and cannot allege that any notice and cure process changed the ability of an actual voter, because that comes back to there's no challenge that anybody who voted wasn't a qualified Pennsylvania elector.
We're going to get through his argument and then I'll wrap up the stream. And we will probably continue this maybe even tomorrow. I'll see what my schedule is, because some more stuff happens after this. Like I said, we're 1 hour into a 4 hour hearing. So, excuse me. But we are going to finish up this opening oral argument from this guy before we get into the part where the judges ask the parties questions. And then I may bring uncivil law on if he's available for that second part. Once I figure out my schedule, I'll do it, because I know he's got some stuff to say. If he'd be willing to join me, that might make for a fun show too.
Voters in the Commonwealth could vote by mail or in person. That was equal throughout the Commonwealth. That was a choice. And let me pause there, Judge, because I think at this point, that choice for mail-in ballot was passed bipartisan in the Commonwealth. It was passed by the Republican legislator and signed by Governor Wolf. Okay, so to the extent there was some suggestion that any party, and in fact it was passed, and Secretary Bookbar and her team worked hard to make sure everybody in the state was able to vote however they chose during the pandemic. And any suggestion otherwise is just not true. But also, we go to the claim that, wait, some voters got to vote a provisional. But again, Judge, that's expressly permitted and required under the Pennsylvania Election Code. All the U.S. Constitution requires, and I'm going to get to the cases, is that a person have the right to vote and that the plaintiff voters do not dispute here that they had the opportunity to vote. I agree with Mr. Giuliani. Both of them said, we mailed in our votes, we did it wrong. They were what we call naked ballots. But there's no dispute. They admit that. They had the opportunity to do that. Now, because plaintiffs cannot demonstrate any burden on the right to vote, they had the opportunity. They say, well, allowing other citizens to cure defective ballots before the close of the polls. For your honor, it's rational basis. And there I would refer to the Husted case out of the Sixth Circuit, 697 F3rd at 429. And that's then rational basis. And there's plenty of reasons to have such processes. Some counties might have known they were going to have higher rates of mail-in ballots. And the counties can allocate resources, Judge, differently without creating a constitutional issue. And I'm going to go through those cases. And just a couple other related examples, Judge. Different counties have different number of polling places. That's been determined. That's not an equal protection claim.
Hey.
Judge Ranjan, in the campaigns case, said, well, wait, having more drop box locations in some areas, that has higher fraud, they alleged. And Judge Ranjan said, that's not an equal protection violation. It's just
That's what I said earlier, except I hadn't listened to this part yet. So, go me.
Not. And the plaintiffs also cannot argue that the counties were somehow limited from having cure processes only in certain counties. The secretary, Judge, I know it's attached, the secretary issued her guidance to all counties, and encouraged all counties to make information available to both the parties and to put it in the SURE system. The fact that some counties may have emphasized these more than others is simply not a constitutional violation. And Judge, plaintiffs don't grapple with these cases
Why,
that are...
why isn't it?
I'm sorry?
Why isn't it, if indeed?
Yeah, and I'm going to start with going through those cases, Judge, and...
That's all right. Then weave it in.
Yeah, okay, thank you.
Weave that in right.
You were a little ahead of me. That's where I'm heading now, though. And Judge Ranjan, let me start, found that the counties may, consistent with equal protection, employ entirely different election procedures and voting systems within a state. And that's slide, maybe one forward. Yep. On the next slide, Judge, it shows that if this were a true equal protection problem on slide 13, then it would transform every violation of state election law, and actually every violation, into a potential federal equal protection claim requiring scrutiny of the government's interest in failing to do more to stop. That is not the law. And then when we look at slide 14, Judge, again from Judge Ranjan, again, there they were challenging different drop boxes in different counties. On slide 14, he held that the counties may, consistent with equal protection, employ different election procedures and voting systems within a single state. And that's what I want to turn to for a moment is the Trump campaign's case against the Secretary in the Western District. With the decision from Judge Ranjan, they're here. They didn't appeal that decision. And the time has passed. And I want to explain why this claim now is not a constitutional violation. Because these nearly identical equal protection theories were asserted by the campaign in that case. There, just like here, the campaign alleged that Pennsylvania's uneven use of drop boxes in different counties violated equal protection for voters in counties without drop boxes. They said one county and the other. And Judge Ranjan, and this is at star 38 of the Westlaw decision, and he kind of goes through it, Judge. Here, he held that equal protection does not mean that all forms of differential treatment are forbidden. And actually, Judge Ranjan held the campaign's equal protection claim, quote, fails at the threshold because the plaintiffs have not alleged that Pennsylvania's system of different use of drop boxes, or here different cure processes, will result in the dilution of votes in certain counties and not others. This goes to the point, it's a statewide. After analysis, Judge Ranjan held his rejection of the equal protection claim is consistent with many courts that have recognized that counties may, consistent with equal protection, employ different election procedures and voting systems within a single state. And that's at star 44 of that opinion. And Judge, before I proceed, I want to address, Mr. Giuliani addressed Bush v. Gore. And a couple points. First of all,
Okay. This is a very boring part of the argument because he's just laying out the bevy of authorities that stand opposed to the Trump campaign. And again, importantly, to the argument they made in this case. The most frustrating part of this is that hypothetically, theoretically, there are valid arguments that could be brought, and they haven't done it. That's the frustrating part of this, is that I saw someone talking about them shutting down counting votes in the middle of the night. Great. They haven't put that in a lawsuit. They haven't brought that claim in a lawsuit. The statistical anomaly. They haven't brought that competently in a lawsuit. Lynn Wood brought it in his lawsuit in Georgia, and there's a whole bunch of problems with how he brought it, and you can see some of those in my most recent live stream about it. I don't want to get too far into it. They're not bringing the stuff they keep trumpeting in the news. All that stuff is coming, and they're running out of time. This is the frustrating aspect of it. Brian Nateran says, just for being an awesome guy. Oh, thank you, buddy. 200 Watt Studio asks, how much is Biden paying you? He's broke. He's got to crowdfund his transition team. He's not paying me anything. Anyway, we'll I think we're almost done. I want to hear what he has to say about Bush v. Gore.
Bulk of the claims here go to notice and cure process, which goes to differences the way counties gave notice, not the way votes are counted. But the flaw in the plaintiff's argument, Judge, is the Supreme Court in Bush v. Gore found Florida's interest in certifying its election results to be paramount. And because they said we got to make sure the Secretary certifies there, they halted the recount there because that was having issues that would prevent Florida from certifying the results. Here, Judge, the plaintiffs are asking you to do the opposite. They're asking you to get in conflict with Bush v. Gore. They're asking you to enjoin certification.
Good counter argument.
They want the court to issue an injunction that prohibits certification. And again, Judge, this isn't the first time this came up. Again, Judge Ranjan's decision at star 42 to 43 addressed the campaign's argument in that case related to Bush v. Gore. And he held that the claim that different use of drop boxes could be an equal protection clause under Bush v. Gore, he said, is wrong. Such dilution, that is, if it actually happens, such dilution impacts the entire electorate equally, not just voters in counties where it occurs, end quote, star 42. And I think that answers the question, judges, for federal court claims, equal protection, even taking what they allege is true, that voter dilution impacts the entire electorate equally, not just voters in the county where it occurs. And Judge Ranjan then held that the alleged harm by the campaign is, quote, categorically different from the harm at issue in Bush and cases like that.
Mr. Donovan, hold on just a moment. I'm told we have some technical issue. Mrs. Reinhardt, what's going on?
All right, I'm going to stop it here at their technical issue. This is a good place to stop anyway. We've basically addressed the standing arguments that are out there. I will personally, in my not on air time, go through the rest of this and make sure there's more worthy content. I know there's some exchanges where the judge is asking questions of the parties. I want to hear that, and I want to share that with you guys. But that is where we're at for today. There's no real point in keeping going. So I'm going to read the chats that have come in, answer any questions that I see in there, and then we will be ending the stream. Thank you guys for hanging out with me today in the middle of the day. I'll try and do more of these daytime streams as my schedule stabilizes. And eventually, I hope to have a scheduled set of daytime streams so people know where to come. If you want to see more stuff, if you want to see non-election related stuff tonight, come hang out tonight at 11 p.m. Mark Kern, former developer for Blizzard, including being on some very important teams with World of Warcraft and other properties, will be on. We'll be talking about big tech censorship in the wake of the election. So it's election adjacent, but we're not going to be talking about like election doom pilling and lawsuits and stuff like that. We're going to be doom pilling on censorship. It'll be all sorts of fun. Nothing but fun streams. Come check that out. We will hopefully talk about navel gazing and all of the stuff that is very important for men to do as well. That should be a fun show, actually, though. It's been a while since Mark has been on, and it'll be really fun to have him back on. But if you're new here, or if you're checking this out remote, on a playback, know that I do typically a live stream every weekday night at 11 p.m. Central. Come hang out for one. They're good fun with the best chat on the planet. So let's read these. Let's read these chats that are here, and then we'll end the show. And then hopefully pick this back up tomorrow, assuming I have time in my schedule to do that, and hopefully with Uncivil Law in tow. All right, Alan Rees says, "Hi, Nick. Have you looked into body language experts regarding Vic Mignogna, Ron, and the Wales Court videos? The Observer YouTuber looks good. I have not. I knew some people wanted to see that happen, but I haven't actually seen the Observer go through it. So thanks for letting me know if that's out there. I'll check it out. Angry Baneling says, extremely early and absolutely hetero. Wow. Colfe 2A wannabe Hunan Muhammad says, early and tri-gendered. Respergoose says, Mr. Ricada, what happened to Giuliani's hair? I don't know. No comment. Connor says, early and straight. I got to get my whiskey. Day drinking. Woo! We are pro-day drinking just like Pennsylvania is now. Reverend Brandon Warr says, the Kraken isn't coming. It never was. It is safe to sail the seven seas of sorrow and hope for the end. Bon voyage, my black-pilled brothers. Look, no, it's the Kraken on steroids now, according to Sidney Powell, after being rebuffed by the Trump campaign and saying that she was not on their legal team, even though they said she was on their legal team. Now she's not on their legal team. She has now said that the Kraken on steroids is coming this week. I know she said she was going to be releasing evidence over the weekend, but that apparently didn't happen. But the Kraken on steroids is coming now after the other Kraken. Just wait and trust the plan, y'all. It's coming. It's coming. Legend of Blue says, it's my birthday today and I'm late and gay. Hey, happy birthday, Legend of Blue. Dean Domino 25 says, nice to catch you live during a weekday. Also, Jeff from World Class BS said he sent you an email for a possible Warhammer 40k stream with Arch, Az, and himself. I have responded to that. I would love to be on the show. Also, just in case he didn't get my response, I'll respond again. And if that doesn't work, you're welcome to clip this out and send it as my official response. Dean Domino says, Sargon mentioned he'd be following lawyer channels on his podcast. I thought you might be one. Saw him in chat now. Crossover when? I don't know. We got to work out a scheduling time for that. I would love to talk to Sargon. Very interesting guy. I've always liked him. So it would be a good show. Seg162 says, why isn't it sufficient to demonstrate the number of ballots in question exceeds the victory margin? They haven't done it. They haven't actually demonstrated that. So that's a problem. I mean, they've said it, but they haven't demonstrated it. And those are two very important distinctions. Donut Swan says, Nick, is there anything illegal about zip tying signs to poles on public property? Does it matter if they are lost dog signs or signs with Nevada Governor Sisolak enjoying a rubber rainbow dog? I don't know. You'd have to check with the local ordinances. I'm not sure. It seems to be political speech. But getting back to that, demonstrating the number of ballots in question, what they've said is they have a whole bunch of ballots that they question. The number is 600 whatever thousand. But that number is like the total number of absentee ballots that were cast in a place where observers weren't allowed to observe. Not the number of ballots that are actually questionable that they've gone in and reviewed. Not the number of ballots that weren't observed. They're like the ballots in the counties. And that number hasn't been fleshed out in a lawsuit. They've just generally alluded to it as part of an argument. So those are the issues. Even if they would just flesh out the number, hammer it down, and put it down on paper and how they got that number, that would be more than what they've done. And that might be sufficient. Super Iron Bob says, isn't this a larger version of what happened in Clark County, that the questionable ballots eclipse the difference? Maybe. Again, in Clark County, they have 139 questionable ballots, 10 vote difference between the two candidates. We don't know how many questionable ballots they have. And remember, in Clark County, the discrepancies appear to be literally people voting twice. That's why it's 139. That's why they know the number. And that's why they're in discrepancy rather than this nebulous sort of stage where they have questions about the ballots. So Clark County seems to be a little bit more particular. A nice McLaren says, hey, Nick, would love to hear your thoughts on Dominion. Do you believe the team should be raising that issue more than the counting of absentee and mail-in ballots in hotly contested states? If they can show anything regarding Dominion and the Dominion software being related to the switching of votes or the tabulation of improper votes, then yes, they absolutely should. My question is, I mean, they're talking about it in the media, but can they actually show it? If they can, why aren't they? I think they have a problem showing it. I think they have a lot of simplicity in inferring it, and maybe that's right, but showing it's a lot harder. Chris M says, you are extra early today, 8 hours or so. So I'm rewarding with the modest donation towards the grift. P.S. I'm late and will end up watching later. Hey, thanks, Chris. Ferno says, first ever super chat, wanted Rackets to be the first. Hey, thanks. I appreciate that. Welcome. Gerard Garvin says, nobody tell Nick he's 8 hours early. Classical positioning says, they have permanently damaged any faith the public may have had in their election process. Yes. In fact, I think they'll need to retool the election process dramatically to restore faith in it. I don't know, and it'll have to be bipartisan. I don't know how else they do it. It's damaged, and it started in 2016. It did not start this year. It did not end this year. It started in 2016, where they spent the last 4 years telling us that the election was rigged. And then now they're trying to tell us that elections can't be rigged. It's amazing. Ferno says, my rule for Rackets to be the first can finally simp VTubers. No! Don't simp them, simp me. Just kidding. Just kidding. Retro Dude Man X says, and Your Honor, why are you dressed up like Batman? Z says, okay, so what do we need to do now to win and put Trump in the White House? You have to lobby your state legislatures to overturn the votes of their people and choose electors that will choose Trump. That's it. That's your only hope at this point. There's a forlorn hope that some other lawsuit will be fruitful. That looks very unlikely, mostly because they're just not bringing the claims they need to bring. They're not bringing the evidence that they're talking about in the media. And I'm very sorry to have to be the guy who breaks that news. I would much rather, believe me, be the rah-rah guy saying there's still a bunch of hope and they're definitely got a plan, because that seems to be very profitable, but it's just, it doesn't seem to be true at this point. If they change that and they start showing some promise, I will happily talk about it. Like I said, I thoroughly believe that there's fraud. I don't know how much. I don't know if it's enough. I don't know, if it can be proved, but my theory has always been elections are too important and fraud is too easy. Of course there's fraud. Of course there is. So we'll see what happens. We'll see what happens. Unknown Existence says, hey, Rackets, what do you think of Jo Jorgensen supporting Black Lives Matter and that she helped steal votes from Trump? The Libertarian Party's a joke. They're terrible. They're not even libertarians, and they should be peacefully sunset with a pillow or whatever. Donut Swan says Dominion got all the PS5s off Walmart.com. See, and that's the theory problem, right? Why would you have Dominion steal an election when what you could do is have Dominion steal pre-orders for Xboxes, PS5s, and 3090s? The math works out in the favor of using Dominion's vast computing power to steal 3090s. So Powell seems to have all the proof. What in the hell is Giuliani's team doing? Powell doesn't seem to have any proof. Powell has said she has proof. Those are very different things. Check this out. I have lots of proof of election fraud. I could prove to you, I release evidence right now showing that Dominion software changed 10,000 votes in every county to Donald Trump from Joe Biden. And I can show you exactly in the code where it automatically, once it reaches a specific threshold of votes within a margin, will switch every fourth vote for Donald Trump into a vote for Biden. Although we added they added some variability in the code to make it so it's every fourth vote plus minus an algorithmic choice between 1 and 3. So you might get every other vote, you might get every seventh vote. We don't know specifically. No one knows how it'll work. What we do know is that it will add a certain amount of votes and then it will go back into a sleeper cell until the margin hits again. There you go. I've just laid out that I have evidence of that, but I can't show it to you. Sidney Powell has laid out that she has evidence, but she just hasn't been able to show it. And I know people got really pissed at Tucker for saying that, but at the same time, she still hasn't shown it. She said she was going to do it this weekend, and she didn't do it this weekend. Now we've got a biblical lawsuit with the Kraken on steroids coming. Let me just posit that there's a possibility that a lawyer out there is bloviating. It's a possibility. I'm just hypothetically suggesting that some lawyers, at least one lawyer out in the world might lie sometime. So that's that. Gerard Garvin says, did the defense counsel come off as a bit of a kiss ass, or is that normal amount of saying judge? You either say judge or your honor. It's better than saying So it could be a way for, is a way for your brain to kind of catch up and get, to your next word or whatever. Saying judge or your honor is a good practice to replace that. Simply just saying judge, it's a call. Pay attention to me, pay attention to me, pay attention to me. It's not a bad thing. It didn't come across as offensive to me. So I think the judge is, there was no risk there to the judge being annoyed with it. Beemitz? I think it's Beemitz. Says everyone was screaming about Russia. No one talks about how China owns so much, including the Dems, and how it meddles in politics. It's almost taboo. Of course it's taboo. You can't talk about China. New York Gamers Federation says, hashtag racket stacks. Anything new on Selman's Folly front? Been locked up with the coup all week, but I get to leave isolation today. So love to hear more good news. Would kill to see this magic happen for you guys. You know what? Right when I end this stream in just a minute, I'll call him. Nate Dogg 1998 says, President Yeezy. All right, guys. Thanks for hanging out. It's been a fun stream. Come back tonight at 11 p.m. Central Time for Mark Kern. Should be fun. That umbrella guy says, Kanye West won, but Dominion hates black people. Okay. Short round. Will I wear my flag like a boxer? Yeah, there you go. I got to go get it. I got notification that it was delivered today. Donut Swan says, black bag these Dominion nerds and make them talk. Maybe they did. I don't know who Kirby Morrow is. Sorry. So no, I didn't hear about his passing. All right, guys. Thanks for hanging out. By the way, if you're new here, hit like and subscribe. We'll see you guys later. I'll play the outro. Here we go. Catch you guys tonight. Have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more a love rug. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all planet folks, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Planing tonight. From the wide shores of Nan to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed.